Okay, welcome to Chapter 6. We're going to be looking at torts. So we're starting a new unit. This unit will be the precursor to the largest unit that we're going to cover here in Business Law 1, and that's going to all be about contracts. But we still have a little bit of groundwork to clear away, and torts is a very important part of this, particularly when we start talking about its relationship to business, because after all, this is a business law course. Okay, so the first question obviously is, what is a tort? Well, in the legal sense, a tort is simply a civil cause of action or a civil wrong for which you may maintain a lawsuit. So why do we have torts? Well, because if you claim you have a right of freedom of speech, a right not to be arrested, a right for a contract to be enforced, you have to have a remedy in a courtroom or a mechanism through which you can enforce your right. If you don't, then that right is meaningless. That right can be violated whenever we want. So not every violation, not everything that is done wrong, or if you want to use a religious term here, not every sin has a remedy. So if someone lies to you, if they say stand you up on a date, they say, oh yeah, I'm going to meet you for coffee at Starbucks at 6 o'clock, and they don't come. Well, you don't have a right to sue them. But on the other hand, certain things that happen, intentional torts, negligent torts, business torts, are the ones that we're concerned about here. And some of these are overlapping categories. These, if someone does something or fails to do something, you have a legal cause of action. You can go into a courtroom and you can sue. Okay, so if you're going to sue, the question is, sue for what? Well, damages is the answer here. At the core of your right is the ability to compel the other party to, in most cases, pay you money for the damage they did to you. Now, we categorize those damages in different ways. Most of the time, we think about compensatory damage. That is, what have you actually lost? What is your financial loss in this situation? Sometimes we look at things like special damages, actual monetary loss. And again, this can relate to compensatory damage. One of the ones that's probably most contentious, and we're going to talk about tort reform in just a moment, is the general damages. And these can be for things that are not an obvious economic loss, like pain and suffering. I mean, what is it worth that you suffered a concussion and you were in pain for a couple days? Can you put a number on that? Or even something more obvious, like, okay, what happens if you lose a pinky or lose a hand? What number can you place on that pain and your long-term loss? Beyond that, we have one of the most contentious areas, and that's punitive damages. Now, punitive damages are designed to punish people. And we're getting perilously close here to the criminal law. But punitive damages actually also serve a very useful societal role. Because if you can't change the criminal law, and very often the weak and the relatively powerless, which means the general public, most people like you and me, have no ability to affect major change as an individual. However, in punishment for outrageous, egregious, intentional behavior, the threat of punitive damages can change major corporations or major individuals, important individuals, can change their behavior. We'll talk about that when we get to McDonald's coffee case coming up. Many pro-business groups, of course, oppose this. Particularly very wealthy, very powerful businesses would, they have at their disposal the mechanisms of power. They can lobby legislatures. They can affect change. And one of the things they've been doing is trying to place caps on lawsuits. The idea being, well, we should be able to do business how we want to do business. We've framed the law already. We don't want to be subject to things like punitive damages. So they want to cap attorney fees. They want to require it more difficult to have lawsuits. Essentially what this is, from the perspective of the individual, not the business, is an attempt to limit their power. So businesses are hoping to limit the individual's power to regulate them. Because as I said, tort is one of the few areas where an individual can have a disproportionate share of power. Intentional torts against the persons and businesses. Now, when we're talking about intentional, we say, did you desire to? It wasn't an accident, but did you actually go out and do this thing? Whether you believed it was wrong or not, different story. But did you go out and do this? Then we make it an intentional tort. And the person who commits this, we use the term a tortfeasor, although I'll have to be honest, in 30-odd years of practicing law, I don't think I use that term very often. Okay, so these intentional torts also have a criminal, I would say almost shadow. So most of these intentional torts we're talking about are, in many cases, also criminal acts. And sometimes we have to dispose of the criminal case before we can proceed with the civil case. And here would be an example. O.J. Simpson was charged criminally with the homicide of his wife and her waiter, Nicole Brown Simpson and Ron Goldman. After that criminal trial, he was also sued by the Brown and the Goldman family and was found liable. So when we talk about many of these intentional torts here, yes, there is a criminal part often that comes first, followed by the civil part. So the first one, which is kind of two combined, is assault and battery. Under the civil law, an assault is a threat of an immediate physical offensive touching. It can be, I'm going to take my fist, I'm cocking it back now, and I'm going to hit you in the nose. That is an assault. I haven't hit you in the nose yet. When I actually hit you in the nose, that's a battery. And we tend to think about things like striking someone with a fist or hitting them with a board or stabbing him or shooting him, and those are all going to be assaults and batteries. But it can be something offensive, like if I came up behind you and licked your neck. That would be a battery. I didn't punch you, but you have a right not to be touched in that way if you don't want to be. So there are certain defenses. For example, did you consent? If a boxer is in a ring and he's boxing his opponent and he gets hit in the face, he doesn't have the right to say, oh my God, you committed a battery. No, you consented to this contact. Self-defense, you hit me, I hit you back. Defense of others, you hit my wife, I hit you back. Defense of property, you stole my wallet, I hit you. So all of these can be legitimate defenses, both on the criminal side, by the way, but also on the civil side to a tort of assault and battery. Now, false imprisonment, and we're going to touch merchant's privilege too a little bit later, but false imprisonment, the kind of criminal analogy here would be what most people would call kidnapping. But false imprisonment means you confine someone against their will. Now, obviously, that can be a criminal act. A person that does that can go to prison. But you also can sue that person. Now, where do we see this most often? We see it most often when a merchant, which is someone who deals in goods of a kind, detains someone they believe is, say, shoplifting. So, does a merchant have that right? Because lots of times when I want to hold someone, if I'm a merchant, the person's going to say, well, you can't hold me, you're not the police. Well, in fact, in North Carolina and many, many places, they have a civil right called merchant's privilege. If a merchant can articulate a reason why they believe an individual is committing a theft or a larceny, and it's a reasonable suspicion, it's not just, well, throw out any bigoted thing you think, like, okay, he's a Muslim, they all steal. He's black, they all steal. He's a white person, they all steal. Whatever you're talking about, that's not a reasonable suspicion. But if a merchant looks at a watch counter and there were 5 watches in it, and there's one person standing next to it, and he turns away for a second, turns back, and now there's no watches in it, well, it's reasonable to believe that he took that. Now, there may be other explanations, but under that rule, he may detain someone for a brief period of time, and if, by the way, the suspicion disappears, if they pat him down, he says, yeah, search me, and there's nothing there, you're done holding him. So you can detain someone for a reasonable length of time till authorities arrive. It's got to be very short. Intentional infliction of emotional distress. This is extreme or outrageous conduct that results in severe emotional distress. This would be something like calling someone up and telling them their children are dead. Or, let's suppose I had a house out in the West where there's been a bunch of fires. I don't know if you've seen the news. So I call someone up and I say, hi, this is the Aurora Police Department and Fire Department, and your house is burned down and your cat and dog that were inside are dead. And it wasn't true. I was just doing it as a prank. Well, that is actionable. I could actually sue that person. Defamation. Now, there's two types of defamation here, so we'll dispose of that first two parts right away. There's slander, which is when defamation is spoken. So you remember that S is S, slander is spoken. And then there's libel, that's defamation that's written. So what's defamation? Well, first of all, it is wrongfully hurting a person's reputation. Now, you've got to tell other people. If I just sit in my room and I write, pick someone you don't like, I don't care. Cal Cunningham, who's running for Senate now, or Tom Tillis, who's his opponent. If you sat there and you wrote, I hate Cal Cunningham, or I hate Tom Tillis, well, it's not defamation till you were to publish that, and then just your hatred is not a falsehood. But if you wrote, Cal Cunningham kills and eats babies, Tom Tillis kills and eats babies, if you publish those things, and they don't kill and eat babies, okay, that's false. You're trying to hurt their reputation. And now we're going to assume that they suffer damage. Now, some things are automatic slander. If you claim someone is inflicted or suffers from a sexually transmitted disease like gonorrhea, syphilis, AIDS, or is professionally incompetent, or has committed a crime, or if it's a woman, and this is just kind of a holdover to the bad old days, that she is unchaste, then those are automatic slander or libel, automatic defamation. There are defenses. Certain speech, if you ask someone in court, does Tom Tillis eat babies, does Cal Cunningham eat babies, and you believed it's true, and you've never told anybody, but you think it's true because you have quote-unquote evidence of it, and you say yes, you can't be sued. Also, if you do this in a political context, if you make a speech on the House floor or the Senate floor, it's protected. Also, public figures like the two people running for Senate here, maybe a good example, Cal Cunningham and Tom Tillis. You've got to show that you make the statement, that it's false, that you injured them, and you made it with actual malice. Malice being translated as ill will or hatred. If you just did it because you were ignorant or stupid or mistaken, that's generally a defense from a public person suing you for defamation. Invasion of privacy, another intentional tort. Generally, you have a right for solitude. You couldn't, let's suppose you're overweight, and someone not known to you takes a picture of you, and they put up a billboard, and they say, overweight, question mark? Try our new protein shakes and lose 50 pounds. Don't be like this individual. Well, you didn't give permission to put a picture of yourself up on a board on the side of the highway, billboard. So you could sue them. So intrusion into individual affairs would be simple as searching a house or without consent, or publishing information that places someone in a false light, and there you're getting very close to defamation, or disclosing information that a reasonable person would find objectionable. So let's suppose that in the past, your spouse suffered from mental illness and was temporarily placed under medical care in a mental institution. Well, that's a private piece of information. If someone published that, and there's no reason to publish it, okay, that would be an invasion of privacy, and it's potentially actionable. Appropriation is very close to invasion of privacy. It's essentially taking someone's name or likeness without permission. Now we get to fraud. So fraudulent misrepresentation has It's one of those terms, by the way, that people throw around. Like, oh, you committed fraud, or that's fraud. Fraud has a very specific definition, and there's a lot of things that, first of all, are not fraud. So let's knock the two things out that aren't first before we go to intentional deceit. One is puffery. So if I say something like, oh, this is the greatest little car in the world, or you're never going to regret buying this air conditioner, that's just talking up a product. We've decided under the law that we call that puffery, and it's not actionable. Also, opinions are not fraud. Will I ever regret buying this car? No, in my opinion, this car is great. You'll love it. So what is actual fraud? Well, first of all, it's got to be false. So let's go to our car example. You go to buy a car, and you say, well, how many, I'm looking for a commuter car. How many miles to a gallon does this car get? And the guy says, oh, it gets 500 miles to a gallon. Yeah, that's the ticket. 500 miles to a gallon. So claims it gets 500 miles to a gallon. That's a material fact. Now, if he had asked, is this a good commuter car? And the guy said, yeah, in my opinion, it's a great commuter car. Even if it's a gas hog. Maybe a commuter car in his mind is something that's comfortable. It's close, but it's not a material fact that's false. So why did he say you get 500 miles to a gallon? Well, he's trying to get you to rely upon that to buy the car. That's the second thing. The third thing for fraud, and this is where you might get in trouble here, is that reliance reasonable? Well, let's suppose it's a new car. Most new cars, they've got the miles per gallon on the window right there. All you have to do is cock your head to the side, look past the salesman, and it says not 500 miles to a gallon, but 10 miles to a gallon. If you had relied upon the salesman, that wouldn't be reasonable reliance. You probably couldn't sue for fraud. But let's just suppose you cock your head, and sure enough, it says 500 miles an hour. Now remember, the car only gets 10 miles to a gallon. So you buy the car. So now we get to the fourth part of fraud. Did you suffer an injury? Well, yeah, it's costing you a lot more money to drive this car. And then the last part is the relationship between the injury you suffered and the misrepresentation. There sure is. But let's go back to the beginning. Let's suppose you go to buy a used car, and the guy said, oh, yeah, this car was owned by Billy Graham. Oh, wow, that's great. I really respect Billy Graham. He was a great preacher. Okay. I'm buying it for a commuter car, but that's great to know. So you buy the car. Okay. You find out later it wasn't owned by Billy Graham. It was owned by his son. Did you suffer a loss? And unless you paid more money for the fact that it was owned by Billy Graham, the answer would be no. There'd be no fraud. Another intentional tort, abusive or frivolous litigation. This is where you file a lawsuit and you have no basis in fact for it. It's not when you lose, because 50% of the time people lose lawsuits. It also can be if you're filing a lawsuit for abusive process, because remember, during a lawsuit you have the process of discovery where you find out information. Let's suppose you wanted to see the books of a competitor. You wanted to see how he's spending his money on advertising and on research. So you file a lawsuit suing him, then you file a motion for discovery to look at his financial records, because from there you can determine those things. That would be an abuse. That would be abusive or frivolous litigation. Okay, so business torts. Here are some. Now, these are often intentional torts, but here's one. Wrongful interference with a contractual relationship. So Cam Newton went from quarterback at the Panthers to quarterback at the New England Patriots. All right, let's suppose you knew that. And you are you're the Buffalo Bills. And you say, we really need a quarterback. So let's go to Cam Newton. And let's tell him to break his contract with New England and come play for us. And tell him, okay, look, we know you got a contract. We know New England will sue you. Maybe they're going to sue you for $1 million. Don't worry, we're going to pay any damages if you break the contract with New England. So Cam Newton breaks his contract with New England and goes to play for Buffalo. Buffalo sues. They can sue under the idea of wrongful interference in contractual relation. Did Buffalo know a contract exists? They did. Did they try to get someone to breach the contract? They did. They're liable. Now, there can be wrongful interference with business relationships, and these can be things like competition. Where capitalist society is fine, but certain predatory acts are not. And again, these kind of get a little vague, but for example, let's suppose you intentionally priced a product so low that you lost a lot of money on it with the intention of driving another person out of the business and then raising your prices. That's seen as a predatory act and could be a wrongful interference in a business relationship. Intentional torts against property. One would be trespass to land. Did you go on someone's land without their permission or stay there? Did you stay in a store after they told you to leave? Typically, they have to tell you to leave, or the land has to be posted in a manner that's reasonably likely to come to your attention. And again, these can be criminal acts as well. There are certain defenses. Is it necessary for you to be in that land? Was there an emergency? Did your car run off the road and that's why your car is on my property? Both of those would be defenses. Trespass to personal property. This is interfering with someone's personal property, like their computer or even something as simple as their pen. If you actually take their property without permission and use it without the intent to keep it, we call that conversion. And that's, again, actionable. Disparagement of property is essentially defamation of property. You slander quality or you slander title. So you say, oh, you're selling Ford automobiles. And you say, oh, Toyotas, they blow up. Yeah, there's a problem with the engine and they blow up and they throw shrapnel everywhere and they kill people. Well, that would be a slander of quality. You're denying that is a good product. You could also commit slander of title. Oh, he can't sell you that Toyota because he stole it. Again, if those two things are untrue, it's actionable that they could sue you. Now we'll get to one of the biggest ones, negligence. Negligence is probably by itself the largest single cause of action for most civil lawsuits. So what do we have to have negligence? Well, there's 4 parts: duty, breach, injury, proximate cause. So let's take a practical example and walk through it. Duty. And the example I use here is a lifeguard at a pool. If you've got a lifeguard at a pool, he has a duty of care. He has to watch the people swimming and protect them. And if he doesn't, he is in the second one, breach of the duty. So our lifeguard should be at the pool, is not. He's at the bar. He's left the lifeguard stand. He's walked over and he's drinking mojitos. Third part, injury. Okay, a child drowns in the pool. Okay, so we've got the duty, we've got the breach, we've got the injury, but we have to establish the 4th thing. If the breach did not occur, could he have saved the child? Or in another way, that's kind of the foreseeability issue. Is the injury, the child drowning, related to the breach? And the answer is going to be yes. If he was in the lifeguard stand and there was a child in the shallow end that he could have easily jumped in and saved, then he was negligent. But let's change this just a little bit. There's a child in the pool. The lifeguard gets off the stand, goes and is drinking at the bar, and a bolt of lightning hits the pool. And the child is killed. So was there a duty? Yes, there was. He should have been in the pool. Was there a breach? Yes, there was. Was there an injury? Yes, there was. Is the injury related to the breach? And the answer there is no. So there would be no negligence. Was he a bad lifeguard? Sure. Is it actionable? No. Now, the duty can be and often is assumed. You take a job as a lifeguard, for example, or a safety inspector. Sometimes, for example, in instances of being a parent or a caregiver, it's imposed. The standard to measure that duty is usually what would a reasonable person do in that circumstance, with one exception. If you have been retained as an expert, you're going to be held to a higher standard. I'm a lawyer. If you get asked, and you're not a lawyer, oh, what's your legal opinion of this? Well, your answer would be held to the standard of what would a reasonable person know about the law? If I'm asked and I give a legal opinion, I'm going to be held to a higher standard. Same with an engineer. If I ask a common person, how many trusses do we need to support this roof? I don't know, 5. Great. But let's suppose I ask a structural engineer, how many trusses do I need to support the roof? It's 5. Let's suppose we needed 10. Well, the common person might not know stress factors, might not be a breach of a duty, okay? But for the engineer, it could very well be. Now, landholders can have some special duties. If you own land, you have to take reasonable care to keep the premises safe because that land's going to exist separate from you. So, for example, businesses should warn customers of any problems. If there is a step up that's awkward or if there's a crack in the sidewalk, they should paint it or mark it. If the floor is wet, they should put out a sign. And you can have liability even if you're a landholder and you don't know the danger exists, but you should have. So someone spills milk in the aisle of the supermarket and it stays there for 2 hours. Well, you know something? Someone in your store should have checked that aisle at least in an hour, much less 2. Also, if you've got someone that deserves special protection, like a child swimming in a pool, you're going to have a greater duty to them, say as a landholder. Professionals can be held to higher standards. I've kind of talked about this already, but you're going to be held to the standards of the industry or your profession for a doctor, an accountant, a lawyer. Also, any suit against them is typically called malpractice. One thing that's thrown in here is the duty of rescue. Somewhat surprisingly, if you're walking down the street and you see someone drowning, and you say, well, you know, I'm not going to save him. I could, but I want to see him drowned. And you watch him drown. There's no civil action against you. There's no criminal action against you. Again, though, if you're the lifeguard and you let them drown, you've got a duty to rescue. Now, in both cases, I'll agree, you might have a moral duty to intervene, and failure to do so places you in a very difficult moral set. Okay, causation. I'd kind of hinted to this. You can analyze the breach and the liability with, would the defendants act, if the defendant didn't act in the way they did, going to the bar or giving the opinion about the trusses, would the injury have occurred? And sometimes we call that proximate cause. What was the act, the last chance to avoid the accident? And often one of the things we engage in around this is we look at, well, could it be foreseeable that the injury would occur? If you come up to me and say, you know, should I stick a sharp object in my eye? And I say, sure, go ahead. And you do it. Well, what was one of the causes of it you did that I told you, sure, go ahead and do it? Yeah, but is it foreseeable that someone would stick a sharp object in their eye? I think the answer there is not usually. So it would be an unforeseeable accident. Therefore, you might have a defense. All right, some of the final points are there are some special negligence situations. Very often these have Latin terms associated with them. One of them is res ipsa loquitur, and that means literally the thing or the act speaks for itself. In certain situations where there is an injury, you don't have to prove much. You just have to prove you were injured and in that situation, and then the people that potentially injured you fight it out. The classic example here is an airplane crash. If you're a passenger riding in a plane and then done nothing wrong, and the plane crashes, what you do is you sue under res ipsa loquitur. You say, I don't know whether it was the airline, so I'll sue them, the manufacturer, the pilot, I'll sue all 3. Let them fight it out. So it really changes the lawsuit from you suing them to them suing each other to determine the degree of liability. There is also instances, rarely, of negligence per se. If you do certain things, you're automatically negligent. For example, usually breaking a criminal law, violation of a statute, often is negligence per se. If you create a danger and someone is trying to help and they're injured, you might be liable for their injuries as well. That's what's called danger invites rescue. There's also Good Samaritan. If you aid someone who's in physical danger and you injure them, you generally can't be sued. Many states have Good Samaritan statutes. Quick example of that would be someone's choking to death and you give them a Heimlich and you break a rib, which can happen. Could they sue you for the broken rib? No. Well, they could sue, but you'd have a defense. Now, what are the big defenses to negligence? Because, yeah, you're going to have a lot of negligence suits, like I said, but there are big, big ways you can defend yourself. One is assumption of risk. This is a huge one. So you get up on a bungee cord and you jump off. And one of the things that happens when people use bungee cords, you know, that's that silly idea. You tie a rubber band to your leg and you jump off of a bridge or a tower or something, is people suffer muscle pulls. Well, no kidding. You're dropping from a height. You're being pulled back, you know, by both your legs or one of your legs or whatever. Yeah, you've got to have known that there was a risk here. So you can't. Sorry about that. I had a bit of an issue with the dogs. Okay, so assumption of risk then is a major defense. You know of a risk and you accept the risk. Superseding cause is something that comes in and breaks the chain of causation. So again, let's go back to our lifeguard in the pool. I think that's a good example. The lifeguard's, the kid starts to drown. The lifeguard is still drinking these mojitos at the bar, and a bolt of lightning hits the pool. Well, this is a superseding cause. It breaks the chain of causation and lets the lifeguard off. Now, the next two terms are very general terms, and unfortunately, they're somewhat confusing because they both start with C, contributory negligence and comparative negligence. So, contributory negligence is the harsher stand, and this is technically North Carolina's stand. It essentially says, okay, we'll look at the negligence situation, but if you are 1% at fault yourself, if we can say, but for what you were doing, you wouldn't have had the injury, even if the other guy was much more at fault, much worse person, you recover nothing. So, example, and I'll use an extreme example that would never work this way, but I'll make it clear in your mind. You're driving down the road, it's a country road, the speed limit is 35, and you're doing 45. The other guy, running away from the police, speeding 100 miles an hour, got a kidnapped victim in the back seat, got a crack pipe in one hand, steering with his feet as he shoots back at the cops with his hand. You come around the curve, he comes around the curve, he's over into your lane. But I could show that theoretically, if you'd been driving the speed limit, you would have been able to just swerve out of his way. Theoretically, in a contributory negligent state like North Carolina, since you had the last clear chance to avoid the injury, you could not successfully sue. Like I said, this is a pretty harsh standard, and most of the time, it's simply not done this way. Most of the time, even in contributory negligent states, they behave as comparative negligence. And this says, okay, going back to our situation, the guy running with the kidnapped victim, driving with his feet, shooting at the cops, drunk. He's 99% at fault, you're 1% at fault. So your injuries are $100,000. Okay, well, we're not going to give you the full $100,000. We're just going to give you $99,000. Okay, at that, we're right around half an hour, 35 minutes, where I like to keep it. And we will pick up with Chapter 7 with the next in our large unit.